This is Behind the Verdict. I'm John Horford with Christina Roscoe Caprone Horford. And not with us today in person, but with us virtually is Myrene Cook. Myrene?
Hi, guys.
Oh, there you go.
Hey. Why did I get Roscoe thrown in there this week?
Because Myrene was talking about how she's watching her daughter's dog, and it just made me think about how my sister Maria says that Christina used to look just like her dog Roscoe when she was growing up.
Well, she says I look like Tucker now, so...
It doesn't make any sense, but just ignore us. Today, we're going to talk about a case that was a listener request from back in June, so sorry it took this long to get to it. The list ended up being a little bit longer than we had anticipated, but this case is a Michigan case from the 80s involving an individual by the name of Temujin Kensu.
Okay. What do you want me to say to that?
No, sorry, I thought you were going to say something because you were like nodding. His real name was Frederick Freeman, and he was convicted of murdering Scott Macklem. So in 1986, a college student named Scott Macklem was gunned down in Port Huron just after sunrise. Within a year, a jury said the killer was 23-year-old Frederick Freeman, today known as Temujin Kensu, and he was sentenced to life without parole. There was a problem. Multiple neutral witnesses placed Kensu 400 plus miles away at the exact time of the murder. So how did the jurors reconcile that? With a theory about a chartered plane, a photo lineup that an expert later called egregiously biased, and a jailhouse informant who would later go on to recant. So this is the story of a conviction that has divided Michigan for nearly 4 decades.
When was he convicted? What year?
The crime happened in 86.
Oh.
So.
I think it was 87.
Okay.
Yeah, so convicted in 87. So,
not like
years
later.
Yeah.
Gotcha.
So a lot of people think, I would say the majority of people think that he is currently being falsely imprisoned, that he did not commit this crime. But there's also a smaller percentage of the population that believes that he's exactly where he deserves to be.
Well, you know what, John? I think I disagree with that a little bit. I don't know that it's a majority of the people that think he's innocent. There are some people that do. Certainly when we get into it, the Court of Appeals and all of those options didn't think so. And I do think there's a lot of people who do believe that he is guilty. So I'm just challenging you a little bit on the majority of that.
I love it. Please challenge more. And clearly the governor and the attorney general don't think that he is innocent of this crime. Was that a fair statement to make?
It is. I have a whole series of things on the appeal when you want to get to that part, though. I did a lot of research on that piece on who it was presented to and what their opinions were.
Yeah. So.
Okay, wait. Where does he say he was when the murder took place?
In the UP, Escanaba area.
And
which, if you're from Michigan, and very far away, like not easy to get to. It's a long drive. You have to cross a massive bridge.
And the murder was in
Port Huron. Do you know where that is?
No.
It was St. Clair County in Port Huron.
Okay.
Yes, far east.
Okay.
Like all the way. So it's a long way to go, which is why people had said that, well, he probably just chartered a plane. Like that was part of a theory. At one point, they had chartered a plane to get down, committed the murder, and then went back.
But what was the evidence that it was just witnesses that saw him in the UP at that time?
He did say that he was able to get a lot of people actually to say that they had seen him at a time that would make it highly unlikely for him to be able to get down to Port Huron and back up to the Escanaba area unless he had flown.
Well, and that was actually a theory that the defense in the trial floated out, was what? Did he charter a plane and then the the prosecutor picked up on it and said, well, that's one possibility, but they believe, as did many others, that he actually drove and that some of the witnesses were mistaken about the time frame that they saw him.
Or that he had intimidated them, because some people were saying that he had like coerced people into saying that they had seen him.
He seemed like that kind of guy.
And that evidence was presented at his trial about the fact that he could have made it there, that he coerced people into saying that he saw them, and that others who claimed to be witnesses to see him also said that they weren't sure on time frames. So that was presented to the jury during the trial.
Should we talk a little bit about the background, like how are these people connected at all, right?
Yeah, I think it's important.
Yeah. Okay.
The victim's girlfriend was a former girlfriend of the suspect, of Kensu. When he was Freeman, Kensu had raped her.
On their first date.
Right. Very intimidating to her and others, and basically told her that he would kill her and her new boyfriend, which was the victim in this case.
Correct. Was there actual proof that he had threatened the boyfriend, though?
There was testimony of that, yes. That is actual proof. I mean, you have testimony in cases, and that can actually be legitimate, direct evidence.
And you believe that they believed that that was the truth, obviously,
yes,
because they convicted him. But,
right, and that was testified to at the trial as well.
Yep. And then some of the things that his lawyer had argued were, one, if he had done this horrible thing to you on the first date, why did you stay with him, right? Which obviously probably ended up backfiring on him.
Yeah, that line of argument tends to backfire. You are now pointing the finger at a victim who didn't know what to do, who maybe liked the person, maybe the person promised not to do it again. I mean, you get into a cycle of violence even very early on in a situation. And sometimes victims don't do the things that we would expect a rational person to do in those circumstances, because what they're dealing with isn't rational. And I've had many a trial where experts come in and testify about that factor, why they didn't disclose sooner, why they stayed with the perpetrator. It happens all the time.
Yep.
I think he also threatened her family as well, like on the first date, immediately.
Yeah, I think so too. And so in that circumstance, she's trying to protect her family.
Yep.
And maybe she's hoping that, he's not going to do it again.
Yep. And so it seemed like he liked to be in control, and it seemed like he liked to play these sort of mind games. And he obviously he has like the name that's associated with the Far East, or that's the connotation that, comes up in people's minds when they hear a name like Temujin Kensu. And it's interesting because was it actually true that he had told Crystal and others that he was part of some like secret order, and if too much information about this order got out, that anyone who knew had to be eliminated? Was that found to be true?
I don't know that was found to be true. I think he made up a lot of lies. I'm going to go back and use a word that John seems to like. I think this guy was as charismatic as OJ to some degree.
Really? I would not have used the C word with this guy.
Yep, and there have been a lot of people who've used it. Even the people on the murder sheet actually said he was charismatic, and he got a lot of people to believe his version of events, even though it turned out not to be true in their opinion.
So, charismatic, pretty manipulative, used to like steal Crystal's car keys, right? She stuck around with him for a little while. They separate. If he was the type that didn't want to let this go and just wanted to control her life, why does he move to the Upper Peninsula?
I mean, that's a good question. What's the real relevance of him moving up there, though? Is it because he thought he would be farther away? Is it because he thought that would make a better alibi? I mean, we don't know, and it's always, in my opinion, hard to second guess why a person like this would do the things they do. Definitely.
So let's talk about some of the evidence. One of the main pieces of evidence that people from the Innocence Project use to say that he was not guilty of this crime. He was shot in a parking lot at St. Clair Community College, and a box of ammunition, right, was found. Is that correct, Marion?
Yeah, that's my understanding.
With fingerprints that did not match Kensu, correct?
I don't believe that matched.
So there was no hard physical evidence linking him to the murder weapon or the scene.
It's not uncommon, though, not to have that right from the get-go. I mean, a lot of times you don't even have the murder weapon in some murder cases.
Yeah, but isn't it interesting that there were fingerprints from another individual, but not from the person that they're saying committed the crime on the ammunition?
I mean, it's not uncommon. I can think of a plethora of reasons why you might have that on there, but I mean, that's not conclusive one way or the other, in my opinion.
They didn't test him?
No, they did.
And they didn't find out who it was. Just not a match to him, but they couldn't match it to anybody else.
Yeah, I don't think they matched it to anybody. So their prints
The only way they can match it to somebody, the only way they can match it to somebody else is if that person is already in the system and they have something to run it against.
Obviously, someone who hadn't committed a crime yet or just hadn't been fingerprinted yet. So what's the evidence, in your opinion, that points towards him being guilty of committing this crime?
Well, I don't know that I can go through all of the evidence that points to him being guilty of this crime. What I looked at in a little bit more detail was the people who'd looked into this. And one of those that came forward and gave multiple interviews to multiple different podcasts and different agencies was his own biological daughter. Did you see that?
I listened to one of that.
Yep.
Yeah.
You know, she talked a lot about how her mom, who had gotten away from him, and her had been just abused and threatened and terrorized by this man. And then after she gave her first interview, she said that she was threatened by him from prison and harassed by him from prison.
What kind of threats? Why was he threatening them?
And she just said he was a very abusive man. He was a very bad man. He made threats to kill people all the time. It wasn't anything that was out of the ordinary for him to say. And I get words and actions can mean two different things, but there's a part of the law, it's actually a jury instruction, that says you can look at a person's intent from what they did, how they did it, what they said, and different ways. And I think you have to look at that with the things he said he was going to do. He said he was going to kill him. He was going to kill her too. And maybe he just didn't have the opportunity to kill the ex-girlfriend, Crystal, but the opportunity he took to kill the boyfriend.
Nothing from that episode that you thought stood out? The conversation between the mother and the daughter?
I mean, I just think the mother's story aligned, not aligned, but it was just a lot of the same behavior that Crystal's testimony was explaining, I felt like.
Yeah. So just to play devil's advocate, is it possible that he was this manipulative, abusive, generally bad person, but did not commit this crime?
It's always possible, but apparently it's not probable given what all of the appellate courts looked into. And I think that's really compelling to me.
Yeah. But so you're saying that the testimony of individuals who said that he, had threatened to murder Crystal and Scott should be taken seriously, seen as credible. I totally get that. Should the testimony of the individuals from the UP that testified in his defense or had given statements saying that they had seen him in the UP at a time that would make it impossible, unless he had chartered a plane, to get from the Escanaba area down to the Port Huron area in Michigan?
But I think that's where a disconnect comes, because it's not impossible. He could have made that drive in a vehicle, which is what a lot of different media sites have said, but the chartering of the plane was only one possibility. And again, I point to the fact that during the trial, those witnesses who testified on his behalf, as far as alibi witnesses go, they were actually also cross-examined by the prosecutor and brought out evidence that he had threatened or manipulated them to some degree, or that they didn't know the time frames that they say they saw him. I think this goes back to something we've talked about in multiple cases, is that a lot of times when a case gets picked up by the media, it gets picked up in this case by the Innocence Project. They are looking at some of the sound bites, but not necessarily all of the sound bites. Does that make sense?
Yeah, absolutely. And I know you have your beef with the Innocence Project.
I do.
I know.
I do.
Wait, you want to talk about that now, or should we bring that up at the end?
I mean, we can bring it up just now. You know, the Innocence Project, I think, has good intentions. They look at cases for the integrity to make sure that the person was rightfully convicted, not wrongfully convicted. We don't want innocent people serving time in prison for crimes they didn't commit. As a prosecutor, I would never want that to happen. I would only want them to be imprisoned and to lose their liberty when they have committed crimes. That being said, I think sometimes in some cases, the Innocence Project may get a little bit off the mark. We talked about that a lot in the Scott and Lacey Peterson case from California, when the Innocence Project there got involved. And I had a personal case in Michigan that I tried. It was what used to be referred to as shaken baby, and they changed it to abusive head trauma, and now they're changing it again to something like non-accidental trauma. But basically, it was a shaken baby case where the father had shaken his 2-month-old and caused some bleeding in the brain. And the Innocence Project came in on that case believing that he was innocent, that this didn't happen. And so I had to battle with them and the experts they brought with them during this trial. And this father was convicted. The jury didn't buy that either. And so there was a plethora of evidence that did substantiate the guilt in that case, in the Scott and Lacey case. And in this case, I think with all of the appellate courts and all of the other agencies that looked at this after the convictions, I think we have to give some credence to all of that, because it's not just one agency or one court. There were multiple courts that looked at this.
Yeah. So let's talk about some of the evidence that helped to convict him and some of the evidence that the Innocence Project and some others say seems to be pretty shaky. So
Okay.
2 men reported seeing a stranger who might resemble Kensu around the scene, right? And the one witness had said that they had been hypnotized before testifying. As a prosecutor, how do you feel about an individual going in, getting hypnotized? Like, are they throwing suggestions in there? Like, can someone be manipulated through that? Does that make them an unreliable source?
I mean, I think it's weird having somebody hypnotized. But this, again, was back in the late 80s, so things might have been done a little differently back then. But here's the thing. They could have ID'd him from a photo lineup that people now claim was faulty. They could have ID'd him in different ways. But the bottom line is they actually had to identify him as the person they saw in the courtroom as well. You can't just have an identification of someone based on a prior outside of the court experience. It has to be they identify the person in the courtroom if they're there, and that has to be actually made on the record. So those 2 witnesses would have had to ID him in court.
Yeah, but also you brought up the photo lineup issue. So his background on the photo was completely different than the others, and there were just glaring differences. It's like I don't remember. I think it was like 5 total. Like 4 looked one way, the same way, uniform, and then there was one that stood out. Does your mind not automatically pick up on that when there's literally just one and it happens to be the person that they're working to convict for this murder?
In the law enforcement agencies I've dealt with, they do their best to try to find photographs that are similar enough where you're not having a glaring discrepancy or a glaring difference of physical appearance or hair color or facial hair or whatever else. But I do also remember there being some scuttlebutt about Kensu changed his appearance before the lineups, before the identification. Like he was trying to conceal his identity. And that to me is one thing you can look at. There's a jury instruction that talks about consciousness of guilt. And if you are trying to basically like cloak yourself into a different persona or make yourself look differently, disguise yourself, that's the word I'm looking for, that that can be shown as a consciousness of guilt. And that's something he was doing right from the beginning.
A guy named Philip Joplin testified that Kensu had incriminated himself. And then years later, he recanted that. And he acknowledged that he received community placement instead of prison, and financial benefits were part of the picture that was laid out in the case materials. in later coverage.
Well, whenever you have what people refer to as a jailhouse snitch, those people, when they testify, are cross-examined by the defense attorneys, and they are able to be cross-examined. Did you receive any benefit as a result of your testimony here today? Did you receive any leniency as a result of your testimony here today? Those things would have been ferreted out throughout the trial, and the jury would have had that opportunity to hear all of that. And that's really one of the things I think we miss. Like, it's really easy to come in later and armchair quarterback a trial unless you're there. And so hindsight is always 20/20. Could I have said it differently? Should I have said it differently? Should they have done it differently? All of those things. But what we're doing right now is second guessing a jury who actually had access to all of these evidence, all of these defense arguments, and all of that. And they still found him guilty.
That leads into another question that seemed to be a glaring issue related to this case. His legal representation was an individual that was found to be a drug addict who would buy drugs from clients and was involved in the drug scene in that area. Is that person of sound mind? And are their capabilities at their sharpest?
Difficulty is we don't know if he was under the influence during the trial. But what we do know is the appellate courts looked at that. The appellate courts will overturn a case very quickly on ineffective assistance of counsel. And they will look at that scenario. They will look at those factors very, very egregiously. They will look at it very closely to make sure that the person was given counsel to all the things that should have been done, and that they actually went through and did the right thing. And so that was looked at just so much. And I can't, kind of wait till we get into that appeal part.
Do you want to get into that now? Do we want to go back to...
was there more evidence that you were kind of pointing to, or that you've seen that's been pointed to?
I think those are the main pieces that are leading to kind of like why he's innocent. Like all those neutral witnesses, they had just everyday people who seemingly didn't have any stake in this case at all. It was a decent amount of people. I don't think it was like one or two. I think it was like 9 or 10 said that he was in Escanaba around the time of the killing.
It was quite a few. And I do recall that as well. But again, I point to what was presented at the trial to the jury. Evidence of witness tampering was presented, and the jury didn't buy their statements.
Yeah, but I think they also may have bought that he could have chartered this plane, which we also need to bring up. He was not a wealthy man. He was in his early 20s. He was working paycheck to paycheck. There's no way he could have ever been able to afford a chartered plane to go down and come back. And I know you're saying that the drive was possible, but there were 9 or 10 people, at least, who said that he was in Escanaba, in that area, around the time of the killing. So it's just...
But they were also confused about the time frame to some degree. And quite honestly, from what I've seen and what some of the other experts I've looked at said, they didn't feel he chartered a plane. They felt he drove. I saw a quote from the St. Clair County prosecutor, Mike Wendling, who said he believed Kensu was manipulating the judicial system by his continuous appeals, since none of his arguments were new, and that the victim's family was being forgotten in all of that. And, we've talked about that before. We want to make sure that people are rightfully convicted and placed where they need to be. But I think sometimes in cases like this, it's still overlooked that the victim lost his life.
Yeah.
Right?
No, absolutely. And it's easy for the victim to get forgotten in all of this. And we have a tendency, even though we bring it up, to focus on the individual that was convicted of the crime versus the person whose life was, taken away.
So, as a prosecuting attorney, I have convicted people in trials. And when you are convicted by a trial, you have what's called different appeal rights. If you plead, you have an appeal right, or appeal by right, or by, if you are convicted, let me say this again. back up. If you're convicted at a trial, you have an appeal by right. That means you can appeal everything that was done in that case from beginning to end. The investigation, how the pretrial motions worked, your attorney, did the trial go the right way, did the judge do the right thing, the prosecutor, the defense attorney, all the things. You can appeal everything, including the sentence. And in this case, it went through so many different levels. So it did not one but two appeals in St. Clair County itself for what they called a motion for a new trial. Not one but two. And both of them were denied by saying that the new evidence didn't amount to the standard that had to be done. And then in 2004, they claimed there was sufficient new evidence, including an alternative suspect and motive for the murder, and they filed another appeal in St. Clair County Circuit Court. And the judge then ruled that those matters did not warrant a retrial or even consideration for what they claimed that new evidence was. In 2005, the Michigan Court of Appeals reviewed the case and upheld the conviction by the jury. And then when it was presented to the Michigan Supreme Court, they declined the case in January 2006. So what it means when an appellate court declines the case is that there was not enough of a question of law that would need to be decided by a higher court. Nothing was presented in the briefs submitted by the defense that there was enough evidence or enough of an argument to make that the Michigan Supreme Court decided they needed to see it. So then in 2007, Kensu filed for what's called habeas corpus. That's just another way for a person to continue an appeal, and that went for consideration, and that was Judge Denise Hood who ruled. That judge actually ruled in his favor on one ground, that she thought Woodward was one of the witnesses, had not been called to give additional alibi evidence, and that should have been presented. The state attorney general at that point, though, filed an appeal against that decision, and the appeal was upheld, meaning it did not warrant a new trial. I don't know if you guys want to jump in, feel free, because I've just got some more of these to go, but it's up to you.
I mean, no, if you want to continue on that, you can absolutely continue.
Okay. So then in a separate commutation process that led to a hearing in September of 2010, the Michigan Parole Board considered Kensu's sentence. And at the time, Governor Jennifer Granholm denied that motion for clemency or commutation based upon the 11-0 vote of the parole board to deny commuting his life sentence.
Was there any additional details for why all 11 of the members of that parole board denied?
They don't generally write an opinion like the Court of Appeals or the other appellate courts do. And they may have given some statement, but I didn't see the full statement. But when I'm looking at all those things that I just kind of rambled off, you've got motions for new trial in the circuit court the case was tried in, denied on both counts. It was then taken to the Court of Appeals, denied on those counts. It was then looked at least reviewed initially for a question of law that would present an appeal by the Michigan Supreme Court, and they denied that opportunity. And then you move on to another avenue for appellate review, which is the Michigan Parole and Commutation Board. And they said no in an 11-0 vote. I mean, that's pretty compelling to me. And they're able to look at arguments of whatever the new evidence was. They're able to look at all of those things. But I go back to what the prosecutor from St. Clair County said, Mike Wendling, was that Kensu was manipulating the system, and none of the arguments that were being made were new. They were all arguments that were made during the time of the trial that the jury had the opportunity to review.
I feel like this case is really just circumstantial evidence and who you find credible, like what witnesses you find more credible.
Absolutely. I mean, there were literally 9-10 people who said that he was 400 miles away at the time of this killing. And
they said that initially.
Yeah. And then there's a jailhouse informant who had the opportunity to testify, and the jurors got to hear that. And then after he's convicted, he recants as well. I mean, it goes both ways. I see.
It does. But on top of all of those appeals in 2020, the Conviction Integrity Unit set up by Michigan Attorney General Dana Nessel considered this case. And the Conviction Integrity Unit was set up for circumstances just like this, where people claim they were falsely convicted and falsely imprisoned based on, recantations of evidence or based on other types of things. that conviction integrity unit considered the case and decided there was no new evidence that supported the factual innocence claim. Period. So not only did you get to have the appellate routes through the court, and not only did you get to have the governor's appeal and commutation unit look at it, but the Michigan Attorney General's office conviction integrity unit looked at it and said, no, there's no evidence that supports factual innocence.
How many more times can he appeal this?
He's done in the state of Michigan. The Michigan Supreme Court denied. I mean, he could try something federally, but he's not, I don't think, would ever get anywhere with that. And then on top of that, you know, you have two separate agencies, the governor's office and the attorney general's office, who considered it separately in separate years with separate people looking at all of this evidence. And they all said, no, he is rightfully where he should be.
And you agree with that?
I do agree with that, yeah.
I do too.
Do you?
Yeah.
Is it based mostly on his general character and the things that he had done to Crystal and to his daughter and to his former baby mom? I don't know. I don't think they were married.
No, and quite honestly, character can't come into play in a trial like that. It is very rare.
But you know it does.
No, let me finish this.
Oh, sorry.
There is a rule of evidence called MRE, Michigan Rule of Evidence 404B, that talks about character. It's actually 404A, talks about character of the accused. And you can't bring up the fact that he was abusive to the baby mama or to the daughter or to other things unless you meet one of these very narrowly construed areas that talks about motive, intent, opportunity, common plan, or scheme. We call it mimic, and that's how it kind of works. But, you know, generally we can't use the character of somebody. Laws have changed since this case that allows character in cases of domestic violence or character in cases of child sexually abusive activity or child sexual assault. You can use those things to some degree. But back in 1987, that wasn't the case.
What if he testified?
Yeah, and what if people testified and said things that would show that he has a character that was highly questionable, that he was manipulative and abusive? It would be objected to and
it would be thrown out. It would be suppressed.
Would it every time?
Yeah.
So none of these...
Trust me, there are times I would love to get into character of people and I can't.
Yeah.
I can't. Even if I ask the question and the defense objects, the judge rules that their objection was sustained, meaning it was right. And even if somebody answers, which they generally don't because it's cut off pretty quickly, the court would instruct them that that is stricken from the record. It's not part of it. And so his character doesn't come into play. I think we can look at his character now and say, yeah, it does fit his behavior. And that's very strong.
It just makes it seem that much more difficult with the lack of physical evidence in this case. He was convicted on circumstantial evidence. There's no proof that he was in that town. There is no fingerprint. There's no proof that he ever owned a gun like that. So what do you base that on? Like, then how do you actually come to the conclusion that he is 100% without a doubt, or beyond a reasonable doubt?
So you just said that wrong, though. Let me correct that. It's not 100% without a doubt. It is beyond a reasonable doubt. And the law says a reasonable doubt.
Wait, I said that right after.
I know, but you said it first.
Come on. And I knew you were going to say that, which is why I said it after. But yeah, beyond a reasonable doubt.
Okay. But what I tell juries is that the only way you can be 100% convinced and know 100% that a person did a crime is if you were there and you were a witness. Yeah. If you were a witness, you can't be a juror on this case, right?
Yep. We've gone through this.
So what I also explain to juries is that you can take direct evidence, which is you're looking at me on a camera right now. That's direct evidence. Or you can take circumstantial evidence and piece it together like the pieces of a puzzle. So when you look at one piece of the puzzle, you may not get the full picture. If you look at several pieces of the puzzle, you might get an idea, but not until every piece of that puzzle is connected. And my argument is when you connect the circumstantial evidence that they had, and we really haven't touched on all of it, and I didn't have a chance to write down all of the evidence. I was so focused on what the appeals courts did. or what they didn't do, to be honest with you, that you have to look at that piece. And when you put all of the pieces of the puzzle together, that jury did, the appellate courts have, the governor's office has, the AG's office has for their conviction integrity unit, they do not believe he was wrongfully convicted. And, quite honestly, I want to go back to Christina for a second. Christina, you said you think he is where he should be, right? Mm-hmm. What convinces you of that?
I think, like you said, putting the pieces of the puzzle together and hearing the testimonies and the behavior that was just so similar of people who don't know each other. And
But it's based on the evidence that would be tossed out if it had been presented in court.
Wait, what?
No, I don't think that's right.
That's literally what, I promise you, that's what she's saying.
No.
Sorry.
So
I'll hire you right now.
I'm not. I'm just blank. I don't know.
His past behaviors. You're basing this off of his past behaviors. You're basing it off of hearing his daughter talk with with her mother, mm-hmm. and talk about how abusive and how vindictive and how, that he was the type of person to like scare them and threaten them. Like that helped to shape your decision, correct? Or am I wrong?
Yeah, because I felt she was genuine. Incredible.
See, there you go, Marion. That's my point. That's my only point. Like I get it, and I understand why it can't be used, but it would really help to shape people's opinions, very understandably. Like if you find out all these terrible things about an individual, it's hard to think about them in a light where it's like, okay, they're a horrible, abusive rapist, but maybe they weren't guilty of this crime, and it's like, well, I don't know, they abuse women, they've raped women, they probably are. And that was my only point in saying that it did help to shape your opinion on this case. I'm not saying it's bad at all. It's completely understandable. It's so human. But like Maureen says, when you're in court, mm-hmm. especially at this time, that was not admissible. Like it did not fly.
Right.
Correct, Maureen?
That is true, but I think there's enough other evidence that goes to that fact, and I think when you can look at the character after the fact and go, yeah, you know what, that is like the extra nail in the coffin. But I want to touch on one of the things that there's been 2 podcasts that really took different views on this, if you will, 2 other podcasts. And one of them was the murder sheet. And what they said, they reconstructed piece by piece with clarity. They cut through all the noise and they looked at what the evidence was. They started looking at the docket, the complaint, the indictment, the charging documents. They followed the records and read both sides' briefs and arguments. They reviewed sworn testimony. They looked at exhibits. They read appeals and post-conviction opinions. And they came down to what a lot of people have said is that he was convicted rightfully. And one of the things they said that you should take away from that is do not beat yourself up for believing a lie, they said. A lot of people, themselves included, believed charisma is a powerful tool, that a lot of serial killers are charming, and everyone gets duped at some point. But when you look at all of the evidence taken as a whole, just like I did in the puzzle piece scenario, they said that their conclusion aligned with more than just what media has presented. And we know that what media presents is often skewed. It's one-sided. It does, their opinion of guilt matches the rulings of the court, matches the rulings of the jury and law enforcement. And they all concluded that, yes, Kensu killed Scott Macklin.
What was the most damning evidence for the jury? Do we know that?
Well, that's the hard part, because unless the jurors themselves give a interview, we don't know what they latched onto. And sometimes what I may think is like the absolute most glaring piece, like, yes, this convinces me as a prosecutor the person did it, is not what the jury looks at. And so unless the jurors have come out, and I didn't see anything that said they did, unless they've come forward and said, this is what I focused on, the best we can do is assume or guess. And that's always kind of a difficulty, to try to assume what they focused on.
I mean, it feels like what was presented and what probably stood out to them the most, just to make an assumption, like Maureen said, I guess you don't know unless you talk to the members that were on the jury, was that he was a jealous person and that they had a turbulent relationship history. I mean, he literally raped Crystal on their first date.
Right, like the motive was there. It was her new boyfriend, her new ex-boyfriend, whatever.
Yeah. Yeah, and then there were the stranger sightings. There were people who said that they saw someone on campus that looked like him around Kensu around the time of that murder. And then at the time, and you can say whatever you want, that jailhouse statement definitely held weight with someone. Like hearing that he confessed to this crime in jail. Because it's like, oh yeah, he would totally do that. You know, he's trying to like get some cred in there, or, you know, whatever it was. And then for him to go back later and recant that, I mean, I think that's a big deal. Whether and I'm on the fence. I don't necessarily, I don't know. I don't know if he did. I don't know if he didn't. He did not seem like a good person. I don't know if he's become a better person, but I've also heard that he's still kind of aggressive and attacking people, or maybe he just feels very defensive, obviously, because people are, you know, saying that he's a horrible, horrible human.
Well, yeah. I mean, let's be honest, from a lot of different accounts, his own daughter included, they do say he is a horrible, horrible human.
But you can still be a horrible human and not guilty of this specific crime. He could be guilty of many crimes, and it sounds like he is guilty of, you know, some crimes. But there's not enough proof in my mind to convince me that he's guilty of this crime.
But John, how do you rationalize that and reconcile it with all of these appellate courts and all these other agencies who've looked at all the evidence in a deeper dive than you or I have, and they've all said, no, he should have been convicted and he was rightfully convicted, and no, the appeal stands. How do you rectify that with you thinking you're not convinced?
I rectify it by looking at what is, I guess it's what's presented in popular media, in the articles that we read, the Innocence Project stuff, obviously connected with, you know, University of Michigan. Nobody had presented anything that I'm like, oh, damn. Yeah, he really did it. Everything is like, but if he got in a car and drove 115 miles per hour from the Escanaba area down to Port Huron, shot the guy, drove back, and then made sure that he was seen in public, it could have definitely been him. And this jailhouse guy said that he did it, and he was a really bad human because of these things that he did. He sounds like a bad human in a lot of ways. I am not convinced that nothing has been presented that I'm like, oh yeah, he definitely did this. Plenty has been presented that I'm like, oh yeah, he doesn't seem like a good guy, but not that he's guilty of this crime. His fingerprints weren't on. No one can prove that he had a gun, that he owned a gun like this. His fingerprints weren't on the ammo, but there were fingerprints on the box for the ammo. I mean, there's just nothing standing out to me that's like he's guilty of this crime. Guilty of crimes, yes. Guilty of this crime, I just don't see enough here. And in those podcasts that we had shared, in those articles that we had shared, I didn't see anything or hear anything there either. That was just like, oh yeah.
One of the things you said grabbed my attention. You said in any of the things you've seen article-wise presented by the Innocence Project and others, they're only going to present one side. They're not going to present.
Yeah, of course they're only going to, yes, they're going to present one side. But then I was also looking up some from the other side as well, just to see, like, you know, why was he guilty? And right. Yeah, I get it.
But
and
nobody...
even what you're saying and all the stuff that you looked at, like, there's nothing that you're saying that's convincing me that he's 100% guilty of this crime. Like, I'm not like, oh,
because
yeah.
I also didn't go through all the evidence. I went through the appeals, and that speaks to me as a prosecutor. The appeals courts, all of them, had the availability to look at transcripts from the trial, had the availability to look at the evidence, look at the photographs, look at every piece that you and I have not analyzed, and they didn't find him innocent. They didn't warrant a new trial. The governor's office looked at it.
But it's interesting.
The general's office looked at it. They looked at all the evidence, though, John.
But usually, but okay, but these pieces of evidence come out. These issues come out. Why is it still kind of a secret? Like, there's nothing, it would have come out by now. It was almost 40 years ago.
I don't understand what's the secret.
The thing that was like, oh, this is the reason why. You're saying that we don't know what that thing is. Why would we not know? Like, think about all of the cases that we've gone through. That piece of evidence that was the glaring, like, oh, he's absolutely guilty, or she's absolutely guilty, or whatever, comes out. Where is that? I don't see it. I didn't hear it.
Right. You didn't see it. You didn't hear it. I didn't research that part of it. Otherwise, I would have found it. But the difficulty that I think we're missing is that the appeals courts did look at all of the evidence. They did look at all this potential new evidence that people claimed was new and different since the time he was convicted. They looked at all of that ad nauseum. They read the transcripts. They did everything that you and I haven't done, can't do, because we don't have access to all of that. And all of those experts, all of them, the appeals court, the governor's office, the attorney general's office, all of them came to the same conclusion decades apart, that he was rightfully convicted. There was nothing wrong with the trial integrity-wise, and he is exactly where he should be. And that, in my opinion, has to be given a lot of credence.
Again, if that was done, I don't know why it wouldn't be public. It's not like it's so complex and difficult to understand that you couldn't put it out in the general public.
A lot of that is public. I don't know what you're referring to.
But I haven't seen anything like and the people who are saying like he's absolutely guilty. They have not presented anything. I've not heard anything. I know that you're saying it's there, but my point is it shouldn't be this difficult. It shouldn't be that difficult to find. Is my point.
It's not if you look in the right places. So if you want, next time I can pull it, there would be a Court of Appeals opinion that's written, whether it's published or unpublished, that analyzes all of the evidence. That is public. Anybody can pull it if you want.
Then we made a mistake, and we should have pulled that. Our apologies. My apologies. There's someone.
No, I'm
scream.
just pointing that there are things in the public that have that. I don't know if the governor's office made their opinion written. I don't know that for sure. Maybe they did, maybe they didn't. The attorney general's office, I don't know that the integrity unit did that either. Maybe they did, maybe they didn't. But nothing's being hidden, I guess, is my point.
I hear you. I think we're just going to keep going in circles here, though, if we don't stop. Go ahead, Christina. You want to say something?
I don't know if you're going to know this, but what was the prosecution's justification of that he did this with this shotgun, that there's no evidence that he ever bought? Like, how did they frame that, I guess? Do you know?
I don't know that piece. That's not something I looked at, and I apologize for not looking at that piece
John,
closer.
do you know?
Crystal said that she had seen him with a gun.
Yeah. So I understand why this is such a tough case, because there isn't any physical evidence or video proof. It's literally he said, she said. But then I think I agree with Myrene, like once you take a step back and you can look at his character and look at his history of violence and manipulation, I think it is very possible that he did this. And again, the motive and the circumstances line up like so well, I feel. But that's my opinion.
And I think it's hard in cases like this because the media does give us portions of things they want to emphasize. The Innocence Project can do that. Appellate attorneys can do that. But I just think so many different people came to the same conclusion. And I really appreciate Christina's take on this, too, when she's looking at the factors that she's seen and what she believes is true.
Yeah, the daughter and the mom, one thing that stood out to me was the mother actually abandoned her. I don't want to say abandoned, that seems maybe a little more harsh, but basically abandoned her daughter to be able to escape him and get away from him. And she didn't see her daughter for like an entire year, and then she finally got her back, and they didn't go into details on how she did that, but the daughter even admitted, she was like, yeah, I really, I held that against you for a long time when I was a kid, but now I completely understand like why you had to save yourself so you could come save me and get us both out of this situation that we were in. The mother was just very, I don't know, I don't think she's done a lot of interviews. I think she was very hesitant because of the threats to her and her daughter, and he has still reached out to her since he's been in prison. She said she hadn't heard from him maybe 5 years, but usually every 5 years is when he starts reaching out to people again and making threats to the people that are speaking poorly about him. And he seems like a very narcissistic, manipulative person from the testimony, I guess I've heard.
Yeah, and I agree with that. That's really hits the nail on the head of what the prosecutor from St. Clair County said as well.
What are you looking up?
I'm I'm trying to find just more evidence related to, why he's absolutely guilty of this. But every source that highlights this case points out the same things.
Yeah.
And those podcasts pointed out the same things. And then a lot of the evidence that they talked about in that second podcast that Myrene had talked about and that you had listened to and I listened to a couple episodes of, a lot of that wouldn't have been able to have been used in court, according to Myrene, especially at that time. So it's and I get it.
Like, well, I'm not saying you can't use it. You would have had to file a motion and it would have had to fit in one of those parameters. It just doesn't automatically come in.
Gotcha. Okay. That's a good caveat. Oh, and another thing was I don't think that his lawyer was disbarred. I think he was just suspended. Because I know like 30 minutes ago I had said he was disbarred. And someone's like, you idiot.
It's an important distinction.
I mean, it's an important distinction, but people make mistakes. And obviously we're not investigative journalists, despite what people say that you need to be to have one of these podcasts. Actually, you don't need to be anything to have a podcast. You just
part of the problem.
We're definitely part of the problem.
Opinions,
sorry.
And we have opinions, right?
That's it. Like
exactly.
you need opinions, and you need an Alex, and you need access to mics.
Oh, you definitely need an Alex. Yeah. I strongly agree with that one. And you know what? Sometimes, though, I think it's good to have opinions on both sides because it presents two sides of the coin. We can see it differently a little bit, and we've done that in other cases. In other cases, we've seen it the same way. So I think it's good to present it to our listeners and really have them come forward and say, what are your thoughts on this? Do you think he was rightfully convicted or wrongfully convicted, and why?
Yeah, it's very interesting, and I agree with you, Myrene. Like it's good to present both sides, and I genuinely am not sitting here and being like, he's actually this great guy. Like reading some of the articles, like the Innocence Project makes him out to be like a good guy. And he doesn't seem to be a great guy. I know a lot of people make mistakes. Some of the things that he's done, they're like unforgivable things in my mind. Primarily the raping of his girlfriend. It's just like, dude, I don't know how humans come back from that. But I don't have enough proof based on what I've seen, but what I've heard, what's been presented, to say beyond a reasonable doubt, this guy did it.
I did want to circle to, I don't know if we've talked about it too much, but the first podcast you and I listened to yesterday, they thought he was innocent, and they were suggesting people reach out to Governor Whitmer. Oh no, that was an old episode, right?
Yeah, I mean, it was.
But still,
yeah.
That was kind of their take on it all.
Yeah.
But they mentioned like so many times how the prosecution was just making him out to be this really weird guy because he had an interest in
Far East and ninjas and
in martial arts.
Yes, and martial arts, and he was from the dangerous city of Flint, Michigan. Which usually, I mean, if you're not from Michigan, if you're from Michigan, you're like, you know what Flint's about, and there are nice parts of Flint, just like everywhere else.
You want to know a little important tidbit fact about Flint?
You used to work there.
Oh,
I did.
Myrene, you think I forget these things?
Years.
Yeah, they all stick in my head. I don't forget these things, Myrene. Yeah, see, and
good job.
And you
good
survived. You survived Flint. You drank the water.
I did drink the water, yeah.
Yeah, which, I mean, that was a horrible situation.
It was horrible.
With Flint water.
We're not making light of that.
No, not at all. But like, just to say that like a lot of people drank the water in Flint, not knowing. But there are other places in the state and in this country that have similar water issues to Flint as well. And those issues should obviously be addressed. Those are like very human issues. I don't want to like go off on this tangent necessarily, but.
Yeah, so I think in this case, it's just hard because I would love to be able to read the transcript of the trial. I think that would be beneficial to me to say, oh, okay, I can see where this question arose, or, oh, okay, I can explain that and here's why. Transcripts, though, aren't generally always accessible to those outside of the case, unless you pay for it, which can be very pricey.
Yeah. So I guess that's something that we could potentially look into for a future episode. But the dead horse that I know I'm beating from earlier, if there was really something that was glaring to point like this guy, beyond a reasonable doubt, is guilty, that information, it's just so hard for me to believe that it wouldn't be public after all these years and after all these people looking into this case. It's just impossible in my mind. That would be pasted everywhere, front and center. This is again, why.
It can be out there. We just didn't look for that piece from the Court of Appeals.
But it would be clear, is my point. It wouldn't be hidden. It would be clear. Well, and it's not clear.
Not hidden.
But you can't find it. And I didn't find it.
I didn't try to find the appellate opinion. I was looking at the appellate review and what their determinations were. I didn't look for the actual court case itself.
My point is this. If OJ was found to be innocent, but if you want to find very clear details to why he was guilty, how easy is it to find those?
Well, OJ is famous and it became a lot of media spectacle, whereas Temujin Kensu was not famous.
Semi-famous now. I mean, I feel like he's
not on OJ level.
Yeah, I mean, OJ was a different level of fame, but even like, I don't know, like if you want to talk about why Bowman was guilty, very easy, very clear. I mean, and I was going to say Scott Peterson, because most of the evidence in that case was circumstantial, and there was even people who, thought that he was innocent. Like, very easy, very clear, and I know that case, he got famous and it blew up, but you can find clear
like
connections.
The purchase of the boat.
Yes. Him being on the boat, her DNA being on the boat and on the boat dock, even though she didn't even know that the boat existed. Lacey didn't know that the boat existed. Right. The bleaching of the house, the weird thing with the girlfriend.
So I just Googled his name and his appellate opinion, and you can find the appellate opinions on Google.
I mean, we can edit anything. So, I mean,
I don't have time to read through them all day long right now, but I'm just saying that they are out there just to play devil's advocate to your part of, we don't know what they are because they haven't been released. They're there.
Or they have been, and the most damning pieces of evidence are the ones that we keep going over and over again. That we keep going over and over again. There you go. That's beautiful. And to me, I understand why someone could think that would be enough. But for me, it's not enough to say he's guilty of this crime. He's guilty of being a bad person. He's guilty of other crimes. I don't see enough here to say this individual, if I'm on that jury, I don't know that I would say he's guilty.
You have to admit, John, that you don't have all the things the jury had.
For sure. But I also think that the things that were glaringly obvious for the 57th time would be...
But for the 60th time, we don't have what was put before the jury. We don't have a transcript of that. So it's very difficult for us to armchair quarterback. Should they have found him guilty or should they not? Because we don't know all of the evidence that was presented. I think you and I will have to agree to disagree.
Is there anything else we want to touch on? You don't buy the plane theory. You kind of brushed that off, but I feel like a lot of people talked about that plane and made it seem like the plane was one of the most convincing pieces of evidence used to show that it was possible for him to get there in time and to be back, and for those witnesses in the UP's testimony to still be credible, but only if he had flown, not if he had driven.
And, so I don't repeat myself again, I just don't see it that way. The plane was just one option. It wasn't the only option, and it wasn't even the major choice that they were arguing. So
I don't know that that's true. But if that's the truth, then you have to throw out the testimony of all of those people.
And there was arguments to be made why they weren't credible, and that was presented to the jury in detail.
Maybe we do need to become investigative journalists? Do we just let's just throw our lives away and just do this?
I mean, if we had all day, every day to research this and pull up all of the things, and we had unlimited resources to get the entire transcript from the trial, I think then you and I could sit down and look at that and go, okay, here's your point, here's my point, let's see which points line up.
Damn it. Okay, we need to work towards getting to that point in our lives.
So you guys are both quitting?
Quitting what?
Your jobs.
Might as well at this point.
I mean, I kind of need my job though, guys. So not today. I can't do that today.
Someday, maybe we'll consider it. Yeah, I guess if we're gonna keep doing this true crime stuff. I would like to make it more political and focus on a little bit of history, but we can balance it out. I know that Myrene doesn't love that stuff.
Well, it's all about the verdict.
It is. It's behind the verdict, not behind the politics.
Yep.
Yeah, but sometimes they mesh.
That's what I'm saying. It's like sometimes it's a political case and sometimes it's murder.
If you want more political cases, leave us a comment. Let us know. And if you want Myrene to quit her job and to focus on this full time and to look into these transcripts, go rate us. Probably 5, maybe 4. I don't know. Just be honest with your heart. Leave comments. Share it with a friend. And then Myrene can quit and do all this deep dive research that I'm requesting.
But if you'd also like us to focus on more crime, actually behind the verdicts of those crimes, let us know that side of it too.
Please don't take us too seriously. You can find us wherever you listen to podcasts. Thanks for listening.
Thank you.